The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to today's webinar, Countering Economic Espionage and Trade Secret Theft. So welcome, everyone, and thank you for joining us this afternoon. Before we begin, I'd like to remind our audience that if you'd like to access other upcoming webinars for 2018 or the webinar archives, there are links in the emails that you receive from us, and they're on our website, so you can check out some of the archive webinars. I'd also like to remind everyone, if you have colleagues that were unable to make it today live, this webinar session is being recorded, and the links will be posted in the chat box later today. So today we have an hour to do this webinar. Please hold off your questions till after the lecture. There is a webinar control panel on the right side of your screen. Q&A will be held at the end. However, you can type in your questions in the questions box of your webinar control panel, and you can see the screenshot on the screen now. So for those who have questions, just type it in and we'll queue them for our speaker to handle at the end. As I mentioned earlier, this webinar is being recorded. So all you need to do is go to our webinar page. The slides and the video will be available 24 to 48 hours after the webinar concludes. You can also watch more videos or more webinars by going to our YouTube channel. And again, this information will be shared with you in a follow-up email after the webinar. For those of you who are on the phone, please go to our webinar page and you should be able to download the presentation there. It's been made available for you to use. All right, so I'd like to introduce today's speaker. So our speaker today is Special Agent Peter Lapp. He is from the FBI Washington Field Office, and Peter is a recognized counterintelligence expert in espionage, economic espionage, as well as insider threat programs. So he served in the FBI in various positions. So right now he is working in the counter espionage sector to help universities as well as private sector partners combat internal and external threats to to intellectual property theft. So I'll turn it over to Peter now. And Pete, are you there?
I'm here. Thank you, Ria.
All right, thank you.
So I appreciate the opportunity to come and speak to you all on the web here. Haven't done many of these webinars, so I'm hoping that my sense of humor comes through a little bit, and we can balance this a little bit, given that we're the web part of this. Been working in this for the FBI for 20 years now, and my experience is mostly in the counter-espionage and economic espionage world. I had some very notable cases I'm going to use to kind of refer back to. One was the Ana Montes investigation, in which 2001 we arrested an American who was spying for the Cubans, and she was spying while working at the Defense Intelligence Agency as a government analyst with the intelligence community. The connection that she has for this audience, part of this audience, is the fact that she was recruited on a college campus at Johns Hopkins University downtown in DC at the School of Advanced International Studies. And I know that some of you on this webinar represent the academic sectors, if you will, and I want to kind of share with you some experiences about her, how it relates to your world. Even though she wasn't working on research, didn't have access to intellectual property per se, the fact that she was recruited by the Cubans, the fact that she was spotted and assessed, and then ultimately recruited by the Cubans on an academic campus, to me validates the reason why the FBI needs to be engaged with the academic community and have an understanding of what they do, and vice versa. The other case that I had that's notable involves DuPont. It involves trade secrets. And Gary Min, back in 2005, was arrested and convicted for stealing. We stopped counting at $400 million worth of DuPont trade secrets. The sentencing guidelines only go up to $400 million. He probably misappropriated in excess of $1 billion worth of DuPont trade secrets. So I'm going to kind of refer to those two cases because I think it helps make this argument that we're trying to portray here to you all about economic espionage and theft of trade secrets and the counterintelligence problem. So if we go to the next slide, slide 2, it's important to kind of make sure that we have an understanding of terminology. I know in the current events of the world, the word counterintelligence is very prominent in the lexicon of our country today, and foreign intelligence is to a certain perspective, and obviously espionage. We all know what that means, probably, but I'm going to kind of better define it for you all here. And then economic espionage, which is something that probably is not as well known and something that's not as widely understood. But to me, it's the crux of what you all handle, to be frank. So foreign intelligence is other countries, including us, trying to acquire intelligence from our adversaries to better advise the policymakers so that they can make decisions based on the intelligence. The counter to that in the United States is obviously the FBI. We're the lead counterintelligence agency for the country. What is interesting about foreign intelligence and the difference between the U.S. intelligence community and the Chinese intelligence service or the Russian intelligence service is this. Yes, the U.S. intelligence community commits espionage overseas. We steal secrets from other countries for the purpose of bringing that back to the United States, analyzing it, and, like I said, allowing the policymakers to make decisions based on the intelligence available. We don't use our intelligence resources, of which the FBI is a part of, to steal company trade secrets from other countries. We don't go to China using the NSA and the CIA and all these other members of the intelligence community and say, gee, there's this little company in China who's making this knockoff version of Kevlar. We should steal those trade secrets using the CIA and NSA and bring them back to DuPont or bring them back to a competitor of DuPont and give it to them for the purpose of commercializing it. That's not what we do. That's not what our intelligence community is there for. That being said, I think you need to recognize that foreign intelligence services use their professional resources, their intelligence officers and their collection efforts to target your trade secrets. Not necessarily just the FBI secrets, the DIA secrets, the CIA secrets, but also to target your trade secrets that belong to your private companies or your academic institutions. And I'm going to talk a little bit further about how the law defines what a trade secret is, but I want to give you that perspective in terms of it's an unfair fight, in my opinion, because we're not using our CIA case officers to steal knockoff versions of Kevlar or whatever, but they're using their version of the CIA to target your intellectual property, your trade secrets. And to me, that's an unfair advantage. Obviously, the espionage is well known. It's the passing of national defense information, not necessarily just classified information, but national defense information for the purpose of aiding a foreign power or hurting the United States. We're able to, the law was really well written, to be honest with you, because like with Snowden or with some of the other folks manning Reality Winner, we couldn't prove, based on what's available in the public knowledge, we couldn't prove that they were trying to help a foreign power, but we could prove that they were trying to hurt the United States. They were ticked off at something that the United States was doing. So the law covered those types of reasons why they committed espionage. Economic espionage involves trade secrets, and it's the passage of trade secrets information to an agent, a foreign government, or a foreign instrumentality for the purpose of allowing them to commercialize that trade secret. That's economic espionage. It's the harder of the two charges that we have to prove. The other charge that we have that's not as hard to prove is called theft of trade secrets. Obviously, with the economic espionage, there has to be a foreign aspect to this. It doesn't have to be just necessarily a foreign-born individual like Gary Min. Gary Min was born in China, naturalized U.S. citizen. He left the United States to go work in a foreign country. That in and of itself would not make this an economic espionage case per se. We had to prove that he was doing what he did to benefit a foreign agent, a foreign government, or a foreign instrumentality. Theft of trade secrets is a charge that we can use with a case like Gary Min, or if the trade secret goes from Illinois across the state line into Indiana. And we've had plenty of examples of domestic type theft of trade secret cases that are relevant and important. One of them, quite frankly, notably, is the Coca-Cola case. Back, must have been at least 10, maybe 15 years ago, a woman, an administrative assistant who worked in the C-suite at Coca-Cola, literally stole the secret recipe to Coke and reached out to Pepsi and said, "Hey, I've got the secret recipe to Coke. I'm willing to sell it to you for $50,000. Are you in?" And Pepsi said, "Yep, give us a couple of days because we just don't have that kind of cash lying around." And they made arrangements to talk again in a couple of days. And in the meantime, Pepsi called the FBI and said, "Hey, we think we've got a problem and we want to cooperate with you and Coca-Cola on this." So it doesn't have to be necessarily leaving the country to go to a foreign country. It can go across state lines and be utilized to benefit a competitor in the same sector. Next slide, trade secret definition. The Economic Espionage Act of 1996 defines what a trade secret is. It's where economic espionage, it's where theft of trade secret is written. It's the law that we use to prosecute those two crimes. The law here defines what in fact is a trade secret. All trade secrets are proprietary, but not all proprietary information is in fact a trade secret. The FBI is not going to come in to your university, to your startup, to your company and say, "Oh, this is your secret recipe to Kevlar." We don't do that. We're not the experts on what is basic chemistry versus what's tweak chemistry that makes a Kevlar plant produce Kevlar and not go boom. DuPont has created the trade secret that the formulas, the way the plant runs, the certain temperatures that things are cooked at, all that information that's beyond basic chemistry becomes the trade secret. And we're going to rely on companies or rely on researchers to say this is the trade secret as defined by the law. And it's a two-part test in terms of what's a trade secret versus something that's just proprietary. The owner's taken reasonable measures to protect it, number one. And number two, that information, whether it's a formula, whether it's a recipe, whether it's a method, a design, it doesn't matter. A company's taken, there's independent economic value from that. DuPont does not put the secret recipe to Kevlar on its website. That's a reasonable measure. They don't publicize it. You can't, or you shouldn't be able to get access to that without signing a non-disclosure, without having confidentiality rules around that, without there being some system in place. And we'll talk about what are good systems and what are good practices in terms of how to protect these trade secrets. But there's got to be an independent economic value. And it has to be something that, it may be something that's in the R&D phase. Okay, we're creating this formula that's going to actually be the next secret recipe to Coca-Cola. It's going to be Coke 101 or whatever. We haven't yet commercialized that, and that's okay. It can still be considered a trade secret. But you have to take reasonable measures to protect that. And that's where we get to the crux of the protections. I'm going to talk about that after the next slide. So if we can go to slide 4, there's critical decision points that you have to make as an owner of a trade secret. You need to understand that there are potentially criminal avenues that you can pursue vis-a-vis the FBI, but there's also civil avenues that you can pursue. What's been great about the Economic Espionage Act is that in 22 plus years, companies have become a lot more comfortable in reporting to the FBI that they've lost trade secrets, that they've been a victim of either economic espionage or trade secret theft. They've become a lot more comfortable. Early on, companies were very reticent to call the FBI because they were afraid that their trade secret may be further exposed, that if we called the FBI and they did an investigation and they arrested someone and put somebody on trial, that either the prosecution or the defense would put the trade secret up on a big bulletin board in the middle of the courtroom and say, this is the secret recipe to Coca-Cola. We don't do that. We don't have to do that as part of our prosecution. So companies have become much better at making that decision to call the FBI. And I think that's a good thing. You can go the civil route. You can hire an outside counsel and you can do all sorts of breach of contract or cease and desist, all sorts of civil remedies to stop your trade secrets from being lost, commercialized, all these different scenarios. What I will say is that in my experience, these cases are incredibly fast moving. Generally speaking, once an individual has the trade secrets from a company, they're not really willing to stick around for a long time and just hang out. Once they've got what they need, they tend to resign from the company, give their 2 weeks notice, and then within a day or two, they're pretty much out the door. We've had a significant number of cases where we've literally stopped the people at the airport flying out of the United States on a one-way ticket with the trade secrets in their possession. We can do that in the FBI. You can't do that in civil, with civil remedies. You cannot stop someone at the airport. We can do that. We, if there's enough probable cause, can get into a person's home and potentially get back your trade secrets and get back positive control of your trade secrets. You can't do that through civil remedy. Any FBI agent that you talk to about this particular problem, whether it's in the abstract like we're doing now, or whether it's case specific, their goal should be to get back positive control of your trade secrets. That should be their number one goal. It's great to arrest people, and a lot of people need arresting, and that's what we do. We put people in jail. But at the end of the day, what's more important to us is that you get back positive control of your trade secrets, that we minimize as much as possible the exposure and loss of your trade secrets. So that should be the primary goal of the investigation. And then if we're able to put somebody in jail after that, that's great. But you getting back a warm and fuzzy feeling that you've got comfort knowing that all your trade secrets are back in your possession, as best you can tell, that's even more important. This slide here, where we talk about critical decision points, these are things to be thinking about now, before you become a victim, before you notice or stumble across one of your employees downloading at out hours your IP, before you realize that, hey, someone in the marketplace has got a similar product, and one of the people that works for that company used to work for us. That's kind of too late. Be thinking about these questions now before you become a victim, because like I said, these are very quick moving cases. They tend to leave the country real quick. And I think it's important for you to have a corporate posture and a plan right now before you become a victim, as opposed to waiting until it happens and then you're making a whole lot of decisions very, very quickly. Going down to slide 5, I would look at these questions that we're going to ask and look at these in terms of how can we build protocols around our trade secrets to help better protect them. I'm not going to say that if you take slide 5 and slide 6, these, whatever they are, 8 questions, I can't guarantee that your trade secrets are going to be totally protected. We can't do that. That's just not reality. What I can say is that if you put these 8 questions in place, I think you're going to have a better shot of unfortunately, what I call being a good victim, if in fact you are a victim. Here's my point. The trade secret definition that we just read a couple slides up ahead talked about what is a trade secret is what reasonable steps a company has taken to protect those trade secrets. The defense is going to argue that these, in fact, weren't trade secrets. Or the defense is going to argue that you didn't do a good enough job of protecting your trade secrets because you didn't have reasonable protections in place. The defense is going to put the company on trial as their strategy in trying to beat the charges, and they're going to poke holes in your reasonable steps that you took to protect your trade secrets. That is a pattern that we've seen over the years from defense arguments. So therein, do you have a very good policy with regards to storing your intellectual property at home? Are your employees even allowed to work from home? And if so, would it be a problem if they printed out your most precious crown jewel, secret recipe to Coke, printed that out and left it at their desk because they had the authority to work from home? Could they access it, and then could they store it at home? What are your policies with regards to, a lot of people will say, hey, I had to back up my computer to my personal computer before I went overseas because I had to make sure that it was protected. Do you have policies in place that prohibit that? This is an argument that we've seen several times. I was traveling overseas. I needed to back up my computer. That's why I had to transfer my hard drive onto a personal data system at home prior to going out the door and leaving. Would your employee be fired if they were found to be storing IP at home? Again, do they have permission to have a home office? Can they work from home? If they have the most secret crown jewel at the secret recipe for Coca-Cola, if they had it at their house, would that be a problem, or is that prohibited? And then what are the repercussions if that were to be found? Would they be fired? It's hard for us to argue that these are such precious crown jewels that they wouldn't be fired if the secret recipe to Coke was sitting at home in some researchers, scientists, engineers' home office. Before is a big one. There aren't many companies out there. I've seen this as being a good thing in terms of companies are getting much better at issuing work-issued thumb drives and making it a strong rule that employees will not use personal issued thumb drives or personal issued electronic media to connect to their work computers. One of the big things we see is, obviously, if my goal is to steal your trade secrets as a company employee, I've got to get that data, that formula, from the work computer systems to my personal computer systems. So I've got to transfer that, whether I email it from my work email to my personal email and add it as an attachment, whether I stick my personal thumb drive in the computer and then download it. Any variety of ways you can do it, but is it allowed? Am I allowed to, from a company policy perspective, to put in a personal thumb drive? I am. It's hard for me to make that argument that someone who did that, we kind of call that a clue. If I stick my personal thumb drive into an FBI computer system, that's kind of a clue that maybe I'm up to no good, because the government issues me thumb drives, and there's certain rules in place that I could be fired for if I deviate from that. So these are questions you need to be asking, and it's something that good companies that we work with are doing pretty extensively with, in terms of issuing work-issued thumb drives and making a company rule. Next slide. Number 5, we talk about, is it documented that the person has authority to have a home office? Kind of important. Are employees, after they've given their 2 weeks notice, still allowed to have access to the computer system? I refer to this example, the vignette for this example is the Huang case, where Motorola was the victim in Chicago. Excuse me, I'm sorry. Huang, who flew out of O'Hare Airport and was stopped by customs on her way out of Chicago to China, was stopped because she had about $10,000, maybe $30,000 in cash. The intellectual property that she stole from Motorola, she stole while on disability. And although she was on long-term disability, Motorola continued to give her a work-issued laptop. She continued to have access to the network. She continued to have an ability to surf through and find Motorola trade secrets and IP. She was on long-term disability. There's no reason for her to have access to that. And that's clearly was a problem and a mistake. But my point on number 6 is, generally speaking, when someone walks in and says, hey, I'm resigning, I'm giving my 2 weeks notice, the company response should be, that's great. You're getting a 2-week vacation. Good luck. We're escorting you out the door. Not, hey, this really stinks. We now have to transition all of your work to this other person. Can you hang in there for another 2 weeks? You transition to John and transfer all your knowledge and all you're working on. He's going to take over your responsibility, or she's going to take over your responsibility. We have seen folks that in that 2-week notice or while they're on disability actually steal trade secrets, and that's a problem. I think you should think about that as you're doing this. The last 2 points kind of go hand in hand. If you've got in order to have reasonable steps to protect your intellectual property, you've got to have a plan and training in place and document that training. That I've trained my employee on how to handle our crown jewel. We have a policy in place on how to handle the secret recipe to Coke. We've trained our employees on how to handle the secret recipe to Coke, and this is the date that our employee was trained on that. I can document that. Here's their signature. In every affidavit for every espionage case we've ever arrested, Hansen, Ames, Montez, you always see in document number 1 the non-disclosure agreement that they've had. They were trained on the first day they walked in. Here's all the rules and regulations you have on handling confidential and classified information. Sign it and date it. You guys need to have that in the private sector as well. You need to train your employees and document how you train them on your trade secret protections and how do you handle your confidential information. We go to slide 7. I want to talk real quickly about state-owned enterprises. And I want you to understand the difference between the private industry in China, the private industry in Russia, and the private industry in the United States. This chart, I think, is about 2 years old. There are no, out of the top 15 companies in the United States, there are no state-owned companies. When you look at China and Russia, the top 12 companies in China are state-owned. And the top, I think it's 8 or 9 companies in Russia are state-owned. That's kind of a clue. And that's definitely a snippet of how there's very little difference between quote-unquote private industry in China and the state. They're in many ways almost one and the same. And I think that that's very important to understand. We've recently kind of looked at some things that China has put out. There's a Made in China 2025 plan that talks about what it is their goal is in terms of trade secret. Well, they don't say trade secret theft, but that's basically what it is, how they're going to acquire intellectual property. It's something I think that I welcome you all to take a look at outside of this and have a better understanding, because they are going after artificial intelligence. They are going after quantum computing. They are going after advanced materials. And I really worry about the day that if China gets AI and gets big data analytics, how that's going to bounce more so than this trade issue that's going back and forth. I think that's more of the key to a destabilization of what we're able to do internationally in terms of the United States. For those in the academic world, so I know a lot of this doesn't pertain to you all. I think as you look at the trade secret definition, you probably don't see much that applies to you. and I understand that. Research in the academic world is very open. I think that in terms of could research that's being done at the academic level that's not classified, that's not export controlled and restricted, could that research become a trade secret at some point in time? Could you make that argument? I think it's possible. I think it depends on whether you fit the definition that you see. I think it's in slide 3 or 4. Generally speaking, that doesn't fit into what you all do. But what I will say is we've had cases, and I think the most notable case that we've had involves the University of Tennessee, and a professor named Reese Roth, R-O-T-H, who employed a Chinese and Iranian student in the area of plasma research. And the project involved ITAR-controlled technology, wherein the university was not allowed to have non-U.S. citizens work on it. And ultimately, he was charged with violations of the Armed Export Control Act. I would say that's probably a decent case for you to research, get a better understanding in terms of how an academic environment could be susceptible to some kind of violation, if you will, from a counterintelligence perspective. My last point I want to make is in terms of partnerships. I encourage you all to build a partnership and a relationship with the FBI, the local FBI field office that you have. We now have in each 56 field office, we have what's called a private sector coordinator. And I think you saw it at the top of my identifier at the beginning of the PowerPoint. I'm a private sector coordinator. My job is to build relationships between the private sector and the FBI. Each office has a similar person who does that role. Whether you're an academic institution, whether you're a startup, whether you're a company, it's an industry, I would encourage you to know who your private sector coordinator is and reach out to him or her, develop a relationship, and they're going to be your conduit into questions that may come up about whether does this quantify as a trade secret? Is this something that, hey, we've got this individual who has been so suspicious behavior, can we vet this through you to see if there's a case that possibly could be going with this? And build a relationship with him or her now before you become a victim. And that way that call, should you need to make it, is easier because you already are on first name basis with that person. So I'm happy to now open it up for questions.
Hey, Pete, thanks a lot. Yeah, I'm just queuing up the questions here, and I should be able to show you a couple in a few seconds. Just give me here you go. Okay, so our first question is, okay, how real, in quotes, is the threat? How seriously should universities take this?
So the threat to universities is 2 or 3-fold. I think that if you look at the Montez example, there's the threat of foreign intelligence services targeting students while they're young if they can recruit them, whether it's Cuba, Russia, China, it doesn't really matter. Can we get them while they're young and their minds are being molded and their thoughts are being molded? Can we get them to then be recruited and then apply to the CIA, the FBI, the intelligence community, or industry? That's certainly a big vulnerability. I do think it's real. I do think that there's a competitive advantage that certain countries want, and that's why they're targeting research while it's in the developmental phase. There's definitely a desire to fast forward through the painful, laborious R&D phase. If they can get to something that's already been commercialized or about to be commercialized and it's finished, they can steal that, then I think that they've just cut and saved a lot of time and energy and cut to the chase if they've stolen that from your university or from your startups. So I do believe that the threat is real. That being said, I don't think that every foreign student that comes here from another country to study, I don't think that there's necessarily a spy behind every tree. I'm not a believer of that. I think there's a select few, but how few that is, I don't quite know, to be honest with you. In terms of how many folks are actually here to target research and target intellectual property and target secrets.
Okay, our next question is, in your experience, what methods are most effective for monitoring your network to detect possible espionage concerns?
That's a great question. I think that data loss protection type software is a definite strong tool. I can't give you specific vendors because that would, inquire that it would kind of suggest that I think one is better than the other, and it's not fair to give that. But I think there's tools out there that track and they surround your IP, they surround a document, they surround a secret recipe, and therefore when that formula moves, whether it's because it's sitting on a computer or sitting on a server or sitting wherever, and then there's a thumb drive that's attached to it and an indicator goes off, I think those are very, very good. They're very good at detecting problems. Now, whether they're false positives or not, that requires different vetting, if you will. I mean, just because I stick a personal thumb drive into my work-issued laptop, even if it's a violation of company policy, doesn't necessarily mean I'm trying to steal it. I could just be ignorant of the rule. I could just be thinking, well, it's expediency. I need to do this quickly, and I don't have a work issue. I've forgotten about the company policy, and I was just doing it just to quicken, expedite transferring this, and I didn't have a nefarious reason for it. So, with these data loss protections, these softwares, these programs definitely has an ability to kind of tip you off and then allow you to vet whether it's a false positive or whether it's something that you should really be concerned about.
Okay, I have another question lined up here. Could you tell us more about what reasonable measures are?
Yeah, the law is really good at not outlining what those reasonable measures are. It starts with the non-disclosure agreement, all the way to termination or voluntarily leaving the company, and what's the exit interview? What's the, hey, you've been reminded that you've been exposed to our intellectual property, and you're further required not to transfer that and not to damage that or expose that. It goes to data loss protection type software. It goes to policies with regards to personal thumb drives. It goes to training. How are we training our employees, and how are we documenting that training? That way, John Smith at the trial can't say, I was never trained on this. You were trained on our security protocols, and here's the date of your training, and this is what you were trained on. But that kind of security type program that's really necessary to be implemented, and to not only protect your employees and protect your IP, but also to, if you do become a victim, help you become a good victim. We're able to kind of stand up and say, we had reasonable protections because we had non-disclosure agreements, we had exit interviews, we had all these different company policies. He wasn't allowed to have a home office. So if he's saying that, he's lying. There was no permission granted to him for a home office. Or if there was, he didn't have permission to download the secret recipe to whatever. This was a violation of company policy, and it's pretty well spelled out in this security protocol and policy.
Okay, thanks, Pete. The next question is a little more, is very specific. Like, are there any vendors of USB drives with known vulnerabilities or backdoors that companies should avoid?
I don't know of any, and I don't know if I did, if I would be able to comment on that publicly, to be honest with you. Yeah, I don't know of any personally per se. I'm not a cyber person. More of an insider threat person, but I don't know of any in this. If I did, I'm not so sure I could say that publicly.
All right, here's our next question. The risks stemming from China in the academic world seem to be increasing based on recent news reports. Can you confirm that this is happening?
I can look at the Made in America or Made in China 2025 program and specifically say yes. They are looking to acquire. I don't have it in front of me, but I want to say it's 5 million in talent. They're looking to recruit 5 million people to come back to China. And I don't think they're coming back just to go to work. I think the expectation is they come back with IP. You know, whether it's something that's being developed in an academic institution or whether it's something that's already commercialized at a Fortune 1000 company. The Made in China 2025 program, to me, is the public example. It's open source. It's what the Chinese are saying they are looking to accomplish. And I would say that, yes, that there's a heightened, increasing counterintelligence threat to China. I know that in the media today, and not just today, but today in general, it's Russia, Russia, Russia. To be honest with you, China is a more significant counterintelligence threat to the United States than Russia is, to be frank.
Okay, so Pete, there is a related question to the Made in China 2025 program. So here it is. Do you have any suggestions on effective legal ways for U.S. companies to counteract the Made in China 2025 program, or at least protect their key assets?
Well, I think it goes back to does your company even have a security program? I mean, some of your companies that are small and in the beginning phase, you know, you're what, 3, 4, 5, maybe 10 people at tops, and you probably don't have a security person yet or focus yet. I think that you've got to have a program. And I can't tell you everything that needs to go into it. I think having a program is a big first step, and having that program focus on more so the insiders that you hire and trust. You know, folks like Anna Montez and Robert Hansen and Edward Snowden and Gary Mann and Juan, all these individuals, they all worked in government or they worked in industry. They were trusted. They had access. We trusted these folks to come into our workplaces, whether it was in government or industry, and gave them the keys to the kingdom. And therefore, there's the vulnerability. I'm not a cyber guy, so I'm not going to sit here and say that I know the cyber threat is real. To me, it's a means to an end. If I can recruit the insider, the engineer who's got the formula, and who might have dual loyalties or have no loyalties to the company and be an entrepreneur and wanting to make an easy buck, that's the person I'm going to target, because he or she has the formula, is probably an engineer and someone who could replicate it outside of a laboratory and hopefully, you know, in my own new company that we're being started up with. So, yeah, I think having a security focus that focuses on the insiders that you've trusted is just wise and prudent. I mean, that's your vulnerability right there, is the folks that you hire. And in this day and age, and I don't even want to say in this day and age, I mean, we don't have the same loyalties to one company that we had in a different generation, where, you know, individuals would work for IBM for 50 years and then retire and get the gold watch and leave. People are bouncing around the companies, different companies all the time, and it's created an environment where there's not quite the loyalty to one particular company for one's professional career.
All right, our next question is, you mentioned partnering with a private sector person in our local FBI office. Does that also apply to public universities?
Absolutely. You know, it's funny. We've had this conversation recently about the branding of the private sector coordinator, and it's confusing because it, on its face, means private sector coordinator only builds relationships with private sector entities. Universities are included with that, and I would make them your conduit to the counterintelligence squad or the white collar squad or the counterterrorism squad. Build that relationship with that person, because he or she should also handle public universities just like they do private industry. The private sector coordinator, unfortunately, is not the best of branding, if you will. But yes, it does include academics.
Okay, I think we have a couple more questions here. So, Pete, are you still okay?
Yep, I'm good.
All right. So the next question is, what is the biggest threat of economic espionage, cyber espionage, or in person?
In person. I think without a doubt, it's in person. And not to say that cyber, you should not be focusing on cyber hacking into your systems and going after your IP and your emails. I think that you should have that concern. My position is that the insider is the bigger threat than the outsider who's hacking in. You're going to have both. Unfortunately, you're going to have both. You have the protections from the outside from a cyber perspective, and you're going to have someone on the inside looking at the employees, looking at how the data is flowing within the organization, and to ensure that people aren't taking it from the inside, because that, to me, is your biggest. We put the most amount of trust in the people who bring in the walls, and we've given them the greatest amount of access. Not that we can't compartment that access, but generally speaking, that's your biggest threat, in my opinion.
Okay, our next question is, if you suspect a concern, how much investigation should the company/university do, and when is it best to contact the FBI and report?
That's a great question. I appreciate that question. It's an art, not a science, because in these cases, because they're so quick moving, so the FBI can't come in and be your corporate security. You know, the minute your data loss prevention tool says, Johnny just transferred a document from, stuck in a personal thumb drive into his work computer, and a document transferred, and it was the crown jewel. We can't just come in and start an investigation based on that. You're going to have to do some due diligence. So I can't tell you that precise moment. It's going to be more of a feel, to be honest with you, but you're going to have to do some due diligence before we come in and do an investigation. We're going to have a certain amount of facts that allow us to predicate an investigation. Perhaps it's, hey, we've got an individual that just stuck in a thumb drive, a personal thumb drive. It's outside of corporate policy. They transferred the secret recipe to Coca-Cola. Oh, and by the way, when we scrubbed their email, we found them talking about the secret recipe to Coca-Cola to this individual who I don't know who they are, and they also booked a flight. Okay, these are facts that then, in my opinion, make it so you should probably call the FBI sooner rather than later. But you can't make that phone call just as soon as someone transfers a document onto a personal thumb drive. That's not going to be enough. We can't be your corporate security. We have too many threats, too many investigations, too many issues. You're going to have someone look, whether you hire someone to come in and do that on a contract basis or not, or whether you have your own individuals doing inside security, that's up to you. But it's something it's a discussion and a conversation to be talking about now before you become a victim.
Okay, our next question is, in your opinion, how much resources should a university or company commit to protecting their IP?
It's a team effort. It's not one individual or one department. To me, the best corporate security folks recognize that they're not one-stop shopping, but it's a team approach. It's human resources having conversations with IT, having conversations with legal, having conversations with the business, the different businesses. More likely than not, the business areas, they're going to know the individuals that are going to be stealing this information better than Social Security will, probably better than HR, although maybe not. Maybe there's been some issues with this individual. A lot of these folks are turned down for promotions. So the different business areas will know, hey, this person's probably kind of ticked off because they were turned down for a promotion. and therefore maybe we should kind of keep an eye on that person, or there's at least a motivation for them as to why they could be sticking the personal thumb drive into the work issue laptop. It's a team effort, and I think the security folks are best at doing the training and awareness, making sure that their security programs, they have one, and number two, that their employees are trained on it. But number three, being that kind of conduit between all the different business areas and parts of the company to build that team that's looking for folks, not just the corporate security folks looking. I think those are the best examples that I've seen within companies that have the best strategy towards protecting their IP.
Okay, Pete, we have 2 more questions. This is the second to the last one. Please, would you clarify the CI and FI terms? So this was at the beginning of the presentation, I think. Yeah.
Sure. I'm sorry, I should have done it better. So CI is counterintelligence, and FI is foreign intelligence. The U.S. intelligence community collects foreign intelligence against our adversaries and around the world. That's called FI. CIA collects FI. NSA collects FI. The FBI is part of the intelligence community. We're a unique organization in that we're both a law enforcement agency and a member of the intelligence community. So we're both. Unlike in Britain, where you have MI5 and MI6, you have 2 distinct organizations. One is law enforcement and one is domestic intelligence. We're both. But CI is counterintelligence, and the FBI's job is to identify and neutralize foreign intelligence threats from other countries into the United States. And you're kind of seeing that with, what's playing out with the Russia investigation, is that, we're trying to counter the foreign intelligence threat from other countries trying to target what we're doing. And that's not just elections, but it's our national security secrets, it's our trade secrets, it's a variety of different things. So hopefully that better answers your question.
All right, and our last question this afternoon: should the U.S. IP protection process at the USPTO be more straightforward and less complicated in order to protect the U.S. economic values?
That's a tough question. I've worked with USPTO in the past. Patents are very unique. I know they're target-rich environments for foreign intelligence collection. I know that there are lots of trolling going on out of patent applications. I can't speak to what USPTO is doing, though, to be honest with you. I don't know how to answer that question, to be honest with you. I think what they do is pretty complicated.
Okay, so that's our last question for this afternoon. Thanks a lot, Pete, for your time. And if there are any other questions, or if you have questions for Peter himself, his contact information is on the slide in front of you on the screen. And also, we made the slide deck available for download on our website. So as I mentioned earlier, this session is recorded. So if you want to share it with your colleagues, we'll upload the video for everyone to view within 24 to 48 hours after this webinar concludes. Okay, so before we wrap up today, Pete, do you have any other words or final words for our audience today?
The last point, and it just piggybacks on what you just said. If you're looking for help in identifying who the private sector coordinator is for your area, by all means, send me an email and I will link you up with who my colleague is wherever you're located.
All right, thank you again, Pete, Special Agent Peter Lapp from the FBI Washington Field Office. Thank you for joining us this afternoon, and also thank you to our audience for listening and for sending us really interesting and really good questions. So thank you, everyone. Have a good afternoon, and thank you again, Peter.
Thanks, Rhea. Thanks for all for joining. Thank you.